And welcome back to the second part of the last video. Free alienability. A. Purported reservation of title by seller. One of the primary goals of Article 9 is to encourage the pledge, securitization, and transfer of secured debt. Accordingly, Article 9 takes specific aim at constructual provisions of law that attempt to limit the granting of security interest in or the sale or transfer of secured transaction. Consistent with this policy, an attempt by a seller in an installment sale document to retain title until paid in full is unenforceable and is instead deemed to be only a reservation of a security interest. B. UCC subsection 9, 401, 9, 406, and 9, 408 limits on restrictions that might otherwise impede Article 9. UCC subsection 9, 401B provides as follows. Agreement does not prevent transfer. An agreement between the debtor and a secured party which prohibits a transfer of the debtor's rights in collateral or makes the transfer a default does not prevent the transfer from taking effect. This section makes abundantly clear that the debtor's interest in the collateral may be disposed of or reached by other creditors despite a contractual provision purporting to preclude a transfer, unlike subsection 9406 and 9408 discussed below. Subsection 9401B does not preclude a clause that makes the grant of a lien or transfer an event of default. It only precludes contractual provisions that invalidate the pledge or sale. UCC subsection 9, 406D deal with accounts, except healthcare insurance receivables, and chattel paper, whether pledged as collateral or sold, and with payment intangibles, promissory notes too, the extent that they are pledged as collateral but are not the subject of sales. Section 9, 406D invalidates contractual provisions that restrict or limit liens or sales on accounts and chattel paper only by prohibiting them requiring consent or that classify them as default under the agreement. UCC subsection 9406F does for laws that restrict or limits liens or sales the same thing as UCC subsection 9406D does for contractual provisions, except that UCC subsection 9406F is limited to accounts and chattel paper and excludes leased goods. UCC subsection 2A303 and 9407. UCC subsection 9408A applies to contract provisions relating to healthcare receivables and general intangibles pledged as collateral or sold, and to sales of promissory notes and payment intangibles. UCC subsection 9408 provides that it includes, but it is not limited to, a contract, permit, license, or franchise. UCC subsection 408C applies to the laws relating to healthcare receivables, promissory notes, and general intangibles pledged as collateral or sold, like subsection 9406, subsection 9408. Prohibits contractual provisions and laws that limit the creation, attachment, or perfection of a security interest or sale, or that characterization, the transfer, as a default or breach. UCC subsection 9408A and C, section 9048 deals with enforcement issues very differently, however, from subsection 9406 generally, and subsection 9408 does not interfere with an otherwise effective restriction in contract or under law on the secured party's or buyer's ability to enforce its security interest or purchased interest. Under subsection 9408D, any security interest created under subsection D subsection 9408A and E, despite a contractual provision or law otherwise, will have very limited enforceability as a security interest. Subsection 9408D provides, to the extent that a term in a promissory note or in an agreement between an account debtor and a debtor which relates to a healthcare insurance receivables or general intangibles or a rule of law, statute, or regulation described in subsection C would be effective under law other than this article, but is ineffective under subsection A or C, the creation, attachment, or perfection of a security interest in the promissory note, healthcare insurance receivables, or general intangibles. 1. Is not enforceable against the person obligated on the promissory note or the account debtor. 2. Does not impose a duty or an obligation on the person obligated on the promissory note or the account debtor. 3. Does not require the person obligated on the promissory note or the account debtor to recognize the security interest, pay or render performance to secured party, or accept payment or performance from the secured party. 4. Does not entitle the secured party to use or assign the debtor's rights under the promissory note, healthcare insurance receivables, or general intangibles, including any related information or materials furnished to the debtor in the transaction giving rise to the promissory note, healthcare insurance receivables, or general intangibles. 5. Does not entitle the secured party to use, assign, process, or have access to any trade secrets or confidential information of the person obligated on the promissory note or the account debtor. And 6. Does not entitle the secured party to enforce the security interest in the promissory note, healthcare insurance receivables, or general intangibles. Section 9408 often comes into play with licenses such as software and liquor licenses, in such cases a contract provision or law prohibiting the licensee from pledging the license as collateral is not enforceable, but the secured party may not enforce the security interest without the permission of the owner. Note, Section 9409 has similar provisions for letters of credit. Also note, Section 9406 governs pledges of promissory notes and payments of intangibles, and subsection 9408 consequently applies to sales of this collateral. Thus, in the event of sales of promissory notes and payments intangibles, an account debtor or maker does not have to recognize the buyer. The 2010 amendments clarify that a sale or other disposition of collateral under subsection 9610, secured party sales, or under subsection 9620, acceptance of collateral by secured party in satisfaction of a debt, is governed by subsection 9406 and not subsection 9408. It is also important to note, United States receivables, the secured party may perfect its lien under Article 9, but may not collect directly from the federal government unless it complies with the Assignment of Claims Act of 1940. Compliance is a difficult process, and even if the secured party does comply, the government retains all rights of set-off and recoupment unless there has been compliance by the secured party. The government has no obligation to pay the secured party. However, the secured party is perfected in the receivables. Pick your partner's partner laws. The free alienability provisions generally do not conflict with the various state pick your partner laws. So state of Nebraska, state of Arizona, state of Colorado, whatever state it may be. Laws and provisions. The free alienability provisions are designed to permit free alienability of economic rights, not governance rights. Moreover, an ownership interest in an LLC is a general intangible, and Article 9 does not apply to the sale of general intangibles, but only to the sale of payment intangibles. Nevertheless, some states, such as Delaware and Virginia, have enacted provisions that make subsection 9406 and subsection 9408 alienability restrictions inapplicable on ownership and governance rights of partnerships and limited liability companies. Limits on liability. Secured party has no liability to third parties. Consistent with Article 9 policies of encouraging transactions, UCC subsection 9402 provides that a secured party will not be liable to third parties for the debtor's acts or omissions, whether the claims sound in contract or tort. This section applies to agricultural liens as well. Waiver of defense by account holder. Again, consistent with Article 9, policies are of facilitating the sale and assignment of a secured transaction, UCC subsection 9403, provides that an account debtor may waive and agree not to assert against any assignee any defense that the account debtor may have against the original secured party or assigner. This provision is only applicable, however, when the assignee takes the assignment for value in good faith without notice of a claim of a property or possessory right to the property assigned, and without notice of a claim in recoupment of the type that may be asserted against a person entitled to enforce a negotiable instrument under sections 305B. This provision parallels the holder in due course doctrine of Article 3 defenses that are permissible against a holder in due course under subsection 3-305B continue to apply. The ambit of subsection 9403 is limited to non-consumer transactions. Legislation that provides that an account debtor may assert defense against an assignee in consumer transaction continues to apply. For example, the FTC holder in due course regulations 16 CFR subsection 433.1 hyphen 430 through 433.3 provide that consumer credit contracts must include a legend preserving consumer claims and defense. This provision is deemed applicable even if the legend is not included, and the account debtor may assert claims and defense. Indeed, to the extent any law provides that an account debtor in a consumer transaction may assert all defenses and claims against the assignee, that law trumps. Subsection 9403. Limits of claims against assignee by account debtor. Unless waived by the account debtor as provided in subsection 9403 above, an account debtor may assert all claims and defense against an assignee. The assignee takes subject to all claims and defense, whether they arose before or after the assignment. If the claims or defense arises from the transaction that gave rise to the contract, which include claims sounding in recoupment, the assignee does not, however, take subject to the other claims or defense, such as set-off claims, unless they arose before the assignment. These claims, however, whether they be in the nature of recoupment, set-off, or otherwise, may only be asserted to reduce the amount the debtor owes. These claims also are limited to monetary offset and may not be employed to defeat a replevant's action. Thus, the assignee's maximum exposure is loss of the right to collect the debt. The account debtor does not have the right to an affirmative recovery from an assignee. Once again, this provision is limited to non-consumer transactions. Because the payer of healthcare insurance receivables is an insurance company, this section also does not apply to healthcare insurance receivables. Finally, as noted in official comments 5 to subsection 9404, the right and limitations of an account debtor under subsection 9404 do not apply in a few other cases. Neither this section nor any other provision of article including section 9408 and 9409 provided analogs regulations of the rights and duties of other obligors on collateral, such as the maker of a negotiable instrument governed by Article 3, the issuer of or nominated person under a letter of credit governed by Article 5, or the issuer of a security governed by Article 8. Article 9 leaves those rights and duties untouched. However, Section 9409 deals with the special case of letter of credit. When chattel paper is composed in part of a negotiable instrument, the obligor on the instrument is not an account debtor, and Article 3 governs the right of the assignee of the chattel paper with respect to the issue that this section addresses. Thus, in the case of negotiable instruments, including negotiable instruments as a part of chattel paper, subsection 9403, 9404, 9406, 9408 do not apply. The term account debtor and thus the 9404 rules also do not apply to the assignment of health care receivables and to banks with regard to their right in deposit accounts. Creating a security interest and the scope of a secure interest. I'll come back with that on another video at another time, ladies and gentlemen. Lately, my research has caused me to reevaluate mortgages, promissory notes, and the transfer of title, special warranty deeds, perfected warranty deeds, things of that nature. And so I'll get back to you with more videos on that. We've got some hard-hitting evidence and facts that should be looked at. And if you've got a special warranty deed, ladies and gentlemen, I would advise you to start doing some research as to why a special warranty deed is no bueno. Have a great evening.